We have the right to self-government, to self-determination of land. And the people that are here are going to go back and continue the struggle. This is not an end, it's only a beginning.
Hello, and welcome to this episode of The True Canadians, the podcast. I'm your host, David Wylynko. The podcast is based on the book, also called The True Canadians. I'm the co-author along with Patricia Russell. The opening audio you heard there was an excerpt from legendary Métis hero Jim Sinclair, speaking at a First Ministers Conference in 1987. Today, we're talking with Jason Madden, Métis lawyer, who will be talking with us a little bit about the legal battles of the Métis, the history of the Métis, and a little bit about himself as well. Welcome, Jason.
Thank you.
I'd like to start with this quote I'm going to throw at you, and we'll go from there. It's actually from the book, from the introduction, and it goes as follows. For over 2 centuries, the Métis have fought for recognition as an Indigenous people and as a nation. This struggle has occurred on the battlefield, in the courts, and at the negotiating table, often over issues of governance, land rights, and resources. I thought that was a pretty dynamic opening, and I thought that would be a good thing to jump off with. But first, let's talk about you a bit, Jason. You have a lot of experience. You worked at one point with the Métis National Council. You'll correct me if I'm wrong, but I think it was 2004, maybe before then, and then you moved on from there. How did you decide you wanted to be a lawyer, and how did you decide you wanted to get involved with this struggle that has taken you all the way to the Supreme Court, I think more than once?
Yeah, that's true. I've been there about a dozen times now. I think, where I come from is I'm Métis. I come from historic Métis community in Northwestern Ontario, 4 hours from the Red River settlement in Fort Frances. My family are the Calders, a well-known Métis family. Some of my ancestors come from the Red River. Some come from Northwestern Ontario and Rainy Lake and Rainy River area. I come from a long line of commercial fishermen, but I have no such skills whatsoever, but have always been able to yap a lot and am very passionate about where I come from and my community and the Métis Nation as a whole. And so got involved in Métis politics at a very, very young age as a youth council representative and at the Métis National Council and in the Métis Nation of Ontario as well. And then decided to go to law school. I have always seen the law as a tool. In many ways, towards Indigenous people, it's been used as a negative tool to oppress or to take away commercial fisheries or, stop people from being on the land. In the flip side, I've also seen the law can be a positive tool that can advance Indigenous peoples, and the Métis people in particular, by forcing governments to do the right thing. Because politics often, and, we see this, the right thing isn't often done in politics. It's the, what's the popular thing? What's the convenient thing? What's the gets you reelected thing? And sometimes of moving forward on, Indigenous issues and recognizing Métis rights, that always doesn't align with, the popular politics of the day. And so I've always seen the courts as a way of moving things forward. So I went to law school. And the first case that I ever actually appeared in was the Supreme Court of Canada case in Powley. I was just wet behind my ears in relation to a lawyer. Jean Taillet, who's another Métis lawyer, took that case from trial all the way to the Supreme Court of Canada. I came in at the last part and was there for the Métis National Council and the Métis Nation of Ontario as interveners in that case. And Jean did an amazing job representing the Powley family and the Sault Ste. Marie Métis community over a decade, wins in the courts all the way up, and ultimately a unanimous victory in the Supreme Court of Canada as well. And I can tell you, sitting in that courtroom and then being a part of the decision being released, less than a year from that hearing, I got bit by the bug and said, I'm hooked. And I wanted to do this and, speak on behalf of my people, speak on behalf of my community, advance Métis rights, not just within, from my home community in Northwestern Ontario, but, within Western Canada and Ontario as well. And so I've been practicing now for 20 years and have been in the courtrooms for many of the Métis rights cases that have pushed things forward. I've also been at the negotiation table, whether it's harvesting agreements, the recent self-government agreements, the other land-related claims that Métis are advancing. So it's been a labor of love, and I got bit by the bug 20 years ago, and I'm still fighting. I think that's one of the things you'll notice when you interview Métis is that we're very passionate about our people, our rights, and making sure that we're protected for the next generation as well. Through the work that I've done over the years, have had a front row seat in seeing our leaders and Métis people from communities across from Ontario westward, advance Métis rights and also secure many of the victories, whether those are negotiated or in the courts, that the Métis have made over the last 2 decades. But we're just a drop in the bucket because this struggle has been going on for more than, as you said at the beginning, more than 2 centuries. Our people have continued to always fight for their rights. It's always been 100% clear of that. Fundamental to that is the ability for us to take care of ourselves and as the people that own themselves, and fundamental to that is self-government.
Well, that has been quite a journey. I'm not Métis, Jason, but I am from Red River, or what became Winnipeg, as with many of your relations. And I've been to Rainy River. My first ever summer job was as a newspaper reporter with the Kenora Miner right there on Lake of the Woods. And Rainy River was in the area I would cover. We certainly did not hear a lot about the Métis then, and I spent my entire childhood between Winnipeg and Lake of the Woods. So maybe with the quest now for recognition and through vehicles like our book, that is changing. It seems it has particularly had some major steps forward in recent years. Can you tell us about how the Métis have progressed in their negotiations with Canada over these past seminal years?
So in 2017, the Métis Nation of Alberta and other Métis governments begin to sign framework agreements and memorandums of understanding with the Government of Canada to set up exploratory discussion tables and then formal negotiation tables. And as I said, it's not unsurprising that topic number 1 on those tables is self-government. And in 2019, the Métis self-government recognition agreements are signed between Canada and the Métis Nation of Alberta and the Métis Nation Saskatchewan and the Métis Nation of Ontario. The Manitoba Métis Federation also signs its own sort of arrangement as well. And that really becomes the starting gun for us to set out a clear pathway for how that nation-to-nation, government-to-government relationship between Canada and the Métis governments that represent the Métis Nation within Alberta, the Métis Nation within Saskatchewan, Métis within Ontario, etc., to formalize that relationship through legally binding agreements and ultimately through modern-day treaties that are constitutionally protected. So in 2019, that self-government agreement is signed. The agreement sets out a bit of a roadmap for how you get to a modern-day treaty, self-government treaty. The missing piece for the Métis Nation of Alberta had always been, the Métis Nation of Alberta self-governed itself based upon a set of bylaws, but Métis always knew that we needed our own laws, not bylaws under the Societies Act. We needed our own Métis laws as a constitution to set out who we are, how we will govern ourselves, and really exercise our jurisdiction as Métis governments, as opposed to using Robert's Rules of Order and, bylaws to govern ourselves. And of course, the Métis Nation of Alberta undertakes the largest ratification vote of any Indigenous nation in Canada in 2022 and ratifies the Otipemisiwak Métis Government Constitution as part and parcel of this, moving towards self-government.
I know in Alberta, this has included the creation of an actual constitution, which is quite impressive. And this new legislation we hear about, Bill C-53, is becoming very topical, Jason. It seems, though, that there's been for many, many years a sort of a one-step forward, two-step back complex in Métis relations with Canada. And this is deep-seated. It extends at least as far back as the days of Louis Riel. In fact, in the book, we have this cartoon that is drawn from the famous Schultz cartoon where Lucy is pulling the football away from Charlie Brown. Only in this case, Lucy is John A. Macdonald and Charlie Brown is Louis Riel. This was meant to signify Riel's efforts to negotiate with Ottawa, and Macdonald agreeing to those negotiations, but then sending troops to Red River.
I do want to highlight, though, that our people, it's not because Canada told us to go, adopt a constitution. Our people for generations had been calling for exercising our inherent right to self-government and self-determination in the same way that Riel and Métis and the Red River did in 1869 and 70 when they stood up and declared a provisional government, right? And so these constitutions and this work that our governments have been doing is so fundamental to implementing self-government. But in addition, we've moved forward on formalizing a new self-government agreement that was signed in February 2023. And that's the Métis Self-Government Recognition and Implementation Agreements that were signed with the Métis Nation of Alberta, Métis Nation of Saskatchewan, and Métis Nation of Ontario. Manitoba Métis Federations has signed a similar sort of agreement. And those agreements contemplate upfront legislation that will anchor the future treaties. And I just want to highlight kind of that saying of fool us once, shame on you, fool us twice, shame on us. We've learned by being lucid in the past of having the rug pulled out from under us. And why we focused on this implementation legislation coming and being put in place before the treaties is we've had in the past negotiations happen, agreements are signed with us, and then governments change and they rip up those agreements or they pull the rug out from under us. We've seen that with harvesting agreements. We've seen that with deals that have been negotiated with Métis governments. And what we wanted with this legislation is it will become the legislative anchor for the future treaties to be given legal force and effect and constitutionally protected. So that piece of legislation, which is so central and key to our self-government agreements, is because we don't want to see, that football being pulled out from under us in the future. And it becomes much harder for a government in the future to pull the football out from under us when it's in law and it has been passed by Parliament. If they want to make changes to that law, they have to do it in the daylight hours and they have to go through Parliament to make those changes. And so the leadership of the Métis governments, their strategy was, well, let's lock in or let's get this legislation locked in. Well, we have a government that has been far more positive on Indigenous rights and Métis rights than any other governments in the past. And Bill C-53, which was introduced in June of last year, is the culmination of that. That's the implementation legislation that will anchor these future self-government treaties.
Yes, Bill C-53 is drawing a lot of attention. We'll talk about that and other legislation. You mentioned the 1982 Constitution Act, which was the raison d'etre of our book, which celebrates the 40th anniversary of that act. It was a key milestone, but as the Métis found out, there was so much more left yet to do.
We've been doing a lot of work, as similar to it wasn't easy for our leaders to get Métis included in the Constitution Act 1982. It hasn't been, completely easy to get C-53 through the House of Commons as well as through the Senate. But, this is fundamental to anchoring Métis self-government in the future, but also the legislation recognizes these three Métis governments that are part of the legislation as governments. And I think that what's so seminal or important about the law is that, previously in one of the Supreme Court of Canada cases from 2011, they referred to it that Métis lived in what was called a legal lacuna. And for those who don't know what a lacuna means, it just means gap. And it says, we've lived in this legal gap. And by virtue of living in this legal gap, governments have been able to ignore us. Governments have been able to not deal with us as peoples. And so C-53, once it passes, will fill that legal gap. It will also provide the legal means in the future for how the treaties that are being negotiated will be given legal force and effect and constitutionally protected. But it's really, going back to your original point, it's really, the strategy is to make sure we don't get loosied again and make sure that we're able to anchor and lock in this legislative foundation for future Métis treaties, which have always been, the missing piece, but also they are the constitutional documents that will set out that nation-to-nation, government-to-government relationship that the Métis Nation has always been struggling for. It's also quite interesting that last week, a Supreme Court of Canada decision came down from the Supreme Court in relation to the Child and Family Services legislation that was passed in 2019. There's a lot of similarities between the recognition provided for in what was previously called C-92, or the Child and Family Services legislation, and our Métis Self-Government Act, which is called Bill C-53. Through those pieces of legislation, Parliament affirms and recognizes rights, and it's a positive affirmation.
That is good to hear. In terms of the Métis in Alberta, there's been this development of a new constitution we mentioned and a new government. How did that evolve?
Since the days of Riel, the Métis and the Métis Nation has strongly believed that it has the inherent right to self-government and self-determination. And that has taken, different forms over history. And in particular, the organization that happens within Alberta in the early 1900s, the creation of the Métis Association and its incorporation in 1961. And it's important to recognize that the reason it incorporated in 1961, it had always been a government for people, or a representative of people, but Canada required it to incorporate in order for it to be provided funding, because they needed to flow funding to something with legal status and capacity. And it's a bit duplicitous of saying, well, you required us to incorporate in order for us to, access funding to support programs for our people. But then you use that incorporation against us to say, well, you're not really a government, you're just an association, right? Like, the talking out of both sides of your mouth becomes, quite clear. You told us to go do that in order to, access funding, but then you use that against us. And we went and incorporated, Métis Nation of Alberta incorporated into the Societies Act in 1961 as the Métis Association of Alberta, and established a set of bylaws to conduct its affairs under the Societies Act. But I just want to highlight that even though we use the Societies Act or the not-for-profit corporation legislation as a means to give, legal status and capacity to the association, the Métis Nation of Alberta and the Otipemisiwak Métis governments are Indigenous governments built by Métis for Métis. And the basis for where they get their authority and credibility is not from government, not from the Societies Act, from the people themselves. For over 100 years, Métis in Alberta have come together through Métis Nation of Alberta and have organized and pushed forward on finally getting that self-government, or that nation-to-nation basis recognized. And what was always missing is, if you say you're a government, then why on earth would you rely on bylaws that are creation under a Societies Act? And I remember being at many Métis Nation of Alberta assemblies over my 20 years of doing work for them. And every time, elders, citizens would get up and say, we need a constitution. We need something that pulls our people together and that is based on Métis law, not Alberta's law, not Canada's law. Because if we don't do it based upon, Riel wasn't looking for his mandate from Canada to negotiate. He went to the council and the parishes to get his mandate to say, should we declare a provisional government? And, in that history, it's quite interesting. He had to go back several times because people weren't initially wanting to do that. Some people were concerned that they may get Canada upset. Others were saying, well, we could use the Council of Assiniboia. But, that fundamental belief of our mandate comes from our people and our people get to decide. And so that's what, when I've always heard people at M&A assemblies talk about the need for a constitution, that's their declaration of self-government. That's Métis law, not some other body's law, but it comes from the people for the people. Now, that's been a hard, developing a constitution isn't easy. It took a multitude of years, extensive consultations. A lot of the discussions needed to be hammered out. Like, one of the challenges within the MNA's old constitution or bylaws was that there wasn't clarity about who does what, right? So it said the locals deal with local matters, the regions deal with regional matters, the province deals with provincial matters. Well, anyone can say whatever the matter is. What we needed is clarity is, who is responsible for consultation? And, through those consultations on the Constitution, became clear, that those consultations should be undertaken at the local level through district councils. And that's what the Constitution sets out. There's a series of, a Bill of Rights within the Constitution that sets out the rights of all Métis individuals, sets out what are the rights of the Métis Nation within Alberta as a whole, sets out what is the relationship with the Métis settlements of Alberta. It sets out the importance of repatriating Métis lands. And, a constitution is about a people's vision, and it sets out who they are, and it announces themselves to the world in many ways, shapes, and forms. Similar to the U.S. Constitution, we the people. The Constitution for Indigenous governments also sets out, this is who we are, this is how we're going to govern ourselves, and it's based upon our inherent right to self-government that flows from our pre-existence prior to Canada becoming Canada, not from any recognition that Canada may give to our Constitution. So it took a long time to develop the Otipemisiwak Métis Government Constitution, a lot of consultations. The leadership in Alberta was quite clear that they wanted to provide everyone the opportunity to vote on this Constitution. And I was awed by overwhelmingly 15,000 people came out and voted. Over 55,000 at the time MNA citizens were eligible to vote. That really demonstrates, and in Métis elections, there's nowhere close to that turnout in the past. This was a resounding vote, yes, of moving forward on self-government. And I think that, the MNA, it was the largest Indigenous ratification vote ever undertaken. All individuals had the opportunity to vote within that. And of that 15,000, 97% voted overwhelmingly in support of that Constitution. I think that just shows the strong basis and the overwhelming support that the Constitution has as a whole, because, no other Métis government has had voter turnout like the Métis Nation within Alberta for the ratification of their Constitution for any election ever. And I think it really speaks to how significant and how strongly supported the Otipemisiwak Métis Government Constitution is. And I think what's so important for people to understand is this is based upon inherent Indigenous jurisdiction, Métis jurisdiction, not someone else's jurisdiction, not a delegated jurisdiction. And that is why its implementation is so important, to make sure that, we respect what is set out in the Constitution. Some of the other issues in the Constitution that are established is, we wanted to make sure that there was clarity around, who was represented in different parts of the province, setting up, 22 districts to make sure that a local level of government is recognized, and that local level of government has, in the same way that provinces do, have expressed jurisdictions, that they govern their own affairs, that they have the responsibility to deal with Métis lands within their district, that they have the responsibility to deal with their own administration, that they have the responsibility to deal with consultation and accommodation with industry and other governments in relation to matters that are occurring within those districts. And that's clearly spelled out in the Constitution, whereas it wasn't spelled out previously within the bylaws of the Métis Nation of Alberta, which caused a lot of conflict between the locals, the regions, and the provinces. And the Métis Nation of Alberta Constitution, or the Otipimswak Métis Government Constitution, is based upon this bringing our people together. And I want to highlight that is also another key piece is we're stronger together, right? That Riel went and got the various parishes to come and get his mandate to declare a provisional government. It's the same way of, bringing people together for the resistance in 1885. It's the same way of how the Métis Nation of Alberta has brought communities together in the province, because we know we're stronger together.
That sounds like a great place to take a break. We've been speaking with prominent Métis lawyer Jason Madden. When we return, Jason will delve more into the pattern of Métis negotiations with Ottawa, the key pieces of legislation that are moving things forward even as we speak, and what the Métis hope will come of these efforts.
Hello, this is Audrey Petra. I believe it is really, really important that people understand how long the Métis Nation and the people of the Métis Nation have fought for the right for recognition and their right to self-government. I remember very, very clearly, as a young person, all my life hearing people talk about that. So it was important, but it was also important to realize that documentation was happening as to what that meant. So as we grew and as we became leaders, we knew what our people were looking for. They clearly were talking about looking after our Métis people, having those rights recognized that we've always had, our inherent rights. It began with developing what that would look like. We signed agreements with the Government of Canada, an MOU that talked about what did that mean. Then we signed a framework agreement in more detail of what we needed to do to make that happen. One of the key parts was, as a nation, we needed our own constitution. We did that. We had consultations with our people. We had meetings. We brought it to our annual assembly where our people ratified it. And we had a constitution passed. That was still not the end result. We needed to have that legislated. So no longer would my children or grandchildren or great-grandchildren, however many years down the road, be still talking about the same thing. So of course, Bill C-53 was introduced as the legislation that would do that for us. We are still in the midst of those discussions. But that is a truly important part of the Métis Nation within Alberta moving to becoming that self-governing nation. All of the other things along the way that happened to the Métis, the horrible incident of Scrip, the Constitution Act that our leaders pushed hard for, the court cases, whether that was Powley, Daniels, those cases that moved us small steps ahead to finally get a government to sign those self-government agreements with us, and to now be discussing the importance of legislation. That's the struggles that we faced along the way.
So we're back with Métis lawyer Jason Madden. Jason, elaborate if you can on this legislation you were discussing. Why now? Explain the Bill C-92 decision on Indigenous parenting rights. And Bill C-53 currently before Parliament has a connection to Section 35 of the 1982 Constitution Act, which recognized Métis rights as well as those of First Nations and Inuit.
In the past, governments had always kind of taken this wait-and-see approach of, well, let's get them to go to court first, establish their rights, and once they establish their rights, maybe we'll negotiate with them, as opposed to getting ahead of the bus and saying, we're going to be proactively recognizing rights and saying, no, we recognize you have these rights without you having to go to court or without you having to, negotiate for 20, 30, 40 years. We will get in front of that. And so the C-53 does that through a positive affirmation of recognizing the Métis right to self-government, as well as the Métis governments that are in the Act. And the Supreme Court of Canada unanimously handed down its decision in C-92, which says that sort of recognition is absolutely binding on the Crown, but it should also be applauded. It is exactly what Section 35 calls for, is proactive negotiations and proactive recognition, as opposed to sitting on your hands, or some would say, like an ostrich with your head in the sand, not dealing with these things. So that piece of legislation that was upheld by the Supreme Court of Canada as being constitutionally valid last week bodes very well for C-53, and also the recognition that for a large part, Canada has been based on this myth that there is federal jurisdiction and provincial jurisdiction. And that is an absolute legal fiction. Going back to where I started from, Indigenous jurisdiction is the first jurisdiction in this land. It was here well before Quebec was. It was here well before Canadian laws were imposed. It was here well before provincial laws were imposed. And so what Truth and Reconciliation is about is recognizing that inherent jurisdiction that was on the land far before Canada became Canada and far before provinces became provinces needs to be reconciled with provincial jurisdiction and federal jurisdiction. So Canada is using how the courts call it, a multi-juridical society. We are not just one set of laws. As we know within Canada, there's the common law and there's also the civil law from Quebec. And we also have Indigenous law. And what's really, I think, quite exciting about the C-92 reference that came down last week is the court talks about this concept of braiding these different laws together. So Indigenous law, which C-92 recognizes that Indigenous peoples have the right to pass their own laws in relation to child and family services based upon an inherent right to self-government, and that those laws through C-92 can become recognized as federal laws within the Canadian legal system. Within the Canadian legal system, if a federal law comes into conflict with a provincial law, the federal law prevails. So what C-92 sets up through Section 21 and 22 of that Act is through the recognition of Indigenous law as federal laws, those laws have the force of law and in Canadian law. And if provincial laws dealing with child and family services are inconsistent with those laws, based upon, it's called the doctrine of paramountcy, those federal laws recognizing Indigenous laws will trump provincial laws in relation to child and family services. Now, the court, what courts usually do is they only answer the bare minimum question that they need to. So they don't say, well, what happens when that conflict occurs? What they do say, though, is the way that C-92 is structured in relation to giving that paramountcy to Indigenous laws in the future is constitutionally valid, and it really doesn't allow for Indigenous laws to be the short end of the stick anymore, of kind of going, well, everyone else's jurisdiction trumps yours. And, in particular, also it recognizes that Indigenous peoples can pass their own laws, that we've always had our own laws and we can develop new laws, and those laws can be recognized as just that, laws. And I think that is what is so historic about the C-92 reference. Now, people may criticize of saying the court didn't go as far enough to recognize, a universal right to Indigenous self-government, or that recognize that basic theory that I set out about how, in my opinion, Indigenous laws are the first laws of this country, and they automatically should have, paramountcy and primacy and before other laws. But what the court does is it creates a legal space to make sure that Indigenous laws don't continue to be ignored, and that right that Indigenous peoples have to, make decisions about their own communities and about their own nation and about their own children and their own families, to keep those intact, that through C-92, there is now an ability to ensure that we aren't getting the short end of the stick constantly.
Right. Fascinating. The C-92 decision has certainly received a lot of recent media attention. Maybe this is a turning point, as we mentioned earlier, a transition away from the age-old tradition of Lucy pulling the football away from Charlie Brown?
It really spends a lot of time about recognizing the importance of the United Nations Declaration on the Rights of Indigenous Peoples, which of course is a international human rights document, and really sets it out in great detail about what some of those rights flowing from self-determination and self-government are and what states should do. And the court says very clearly that by virtue of the UNDRIP Act that was passed in 2021, that is now a part of Canadian positive law, and that through the act of C-92, UNDRIP is actually being implemented.
Indeed. The United Nations Declaration on the Rights of Indigenous Peoples, or UNDRIP, has become increasingly relevant. It also led to the Truth and Reconciliation Commission report in Canada, and the calls to action from that do seem to be having an impact in the quest for legitimate reconciliation.
And the court writes a lot about the importance of UNDRIP, and it's being kind of a North Star for how we should work together in the future and what government should do. And so I think that's another important point from C-92, because it really sets the direction. Because going back to what I said earlier about in the 1980s, the leaders were to sit down and try to figure out, what rights are all included within Section 35. And of course, those constitutional conferences were unsuccessful. What UNDRIP really does is it puts some meat on the bones about what all of those rights are and how government should operate. And the more that UNDRIP becomes a part of, accepted of, that's the bare minimum of what needs to be recognized. And that's what we should all be working on implementing in Canadian law and through negotiations. I think that's a great part of the C-92 reference as well, because it makes sure that does act as our North Star about where we're trying to get to and implementing UNDRIP in tangible ways. And of course, last but not least, I'll say, it does the affirmation of, saying that the inherent right to self-government exists, and it includes jurisdiction in relation to child and family services. And the court says that is absolutely valid for Parliament to set out its view on what those rights are. And by virtue of including that in legislation, Parliament has bound itself to operate in that way and to conduct itself in that way. So that's really significant. So in other arguments, they can't be saying at negotiation tables anymore, well, we don't even know if there's an inherent right to self-government, or we don't know if it includes legislative authority in relation to child and family services. Parliament has now bound itself to that position, and the Supreme Court of Canada has been clear of it. The honor of the Crown is engaged by ensuring that it conducts itself in that way. So it's really a significant piece of legislation, and it also complements C-53, because that same rights recognition approach that is in C-53 has now been affirmed by the Supreme Court of Canada that it is a laudable approach. It is a constitutionally valid approach, and hopefully that will give a greater impetus for the passage of C-53 soon, as we've touched base on. We're now through the Indigenous and Northern Affairs Committee study stage, and now ready for third reading, going back to the House of Commons, hopefully soon, and then on to the Senate and ultimately passage. And that is, a really key part of this self-government journey that the Métis Nation as a whole has been on, but in particular, the Métis Nation of Alberta has been on.
This reminds me of our guests from our first podcast, President Andrea Sandmeyer of the new government in Alberta and retired President Audrey Patra. President Sandmeyer recalled the tales of Métis elder Angie Creer, quoting her own father that someday this recognition would come. And President Sandmeyer said that someday is now. It's been a long struggle.
we also have seen what slicing and dicing and carving up our communities and having a legislative scheme imposed on us has done for First Nation. The Indian Act is not, while it does recognize First Nation self-government, it was imposed on First Nations. It was created by parliamentarians and imposed on them, and it cut up and divided their traditional governments, many of their families. They're dealing with the legacy of that colonial and racist piece of legislation today, and they're trying to dig themselves out of it. I've always viewed the Métis reality as it's kind of like we're through the looking glass. So on the First Nations side, they've had control assimilationist policies applied to them. And what we've had is government essentially ignoring, neglecting, denying, and hoping that will just go away, right? Living in what I've referred to as the legal lacuna. What we're digging ourselves out of is that lack of recognition that has plagued our relationship with Canada. And that's why self-government, the modern day treaties is so key. And going back to President Patra's statement that, if we get the relationship right, everything flows from that. And so for the Métis, while First Nations are trying to dig themselves out of the legacy of the Indian Act, we're attempting to finally put in place that nation-to-nation, government-to-government relationship so we're not denied or ignored anymore in the future. It's important, though, that in doing that, we don't want to replicate the mistakes or the things that we see on the First Nation side where their communities are carved up. There's on-reserve, off-reserve divides being created, not of First Nations' own choosing, but of the Indian Act itself and how, Canada funds that. And so when the Métis have built their self-government structures, and they're built upon bringing all of our communities together and making sure no one's left behind. And also we have to recognize that in order to have self-government, you need to have a scale and you need to have the capacity and the ability to self-govern. And that self-government isn't operated by 12 people or 80 people. It requires a level and scale and a capacity to govern. And it also requires that the people who are a part of that or represented by that government want to be represented by that government. Today, the MNA has over 65,000 citizens that willingly mandate it as their government, and they know what the Constitution is, know that this is where, how the MNA will represent them, and they willingly mandate that government to represent them. And so I think it's really important that when you look at why Métis government looks different than First Nations government, one of the things was very clear that, we didn't want to be put on reserves or have our communities carved up into small reservations or settlements. And one of the double-edged sword is we have been able to build self-government structures that meet our purposes, right? The double-edged sword, though, is historically those self-government structures haven't been recognized by other governments, right? So while Canada and Alberta will recognize Indian Act bans, right, because it's a federal piece of legislation, they've historically said, we just think that you're an association and we're not going to recognize you as an Indigenous government. What's so phenomenal about C-53 and about, the Otipemisiwak Métis government constitution is it's based upon Métis laws, Métis inherent right to self-government, and Canada meeting us where we are and recognizing that government on a nation-to-nation, government-to-government basis, not doing a we know best sort of approach and imposing a legislative scheme on us. That is going to be really important, and when people kind of go, these governments don't exactly track to what the historic communities may have been or, what we were in historic times, that's an absolute fallacy to believe that these governments have to replicate that. They don't. The United Nations Declaration on the Rights of Indigenous People say Indigenous peoples can build governments for themselves. And the Métis have done just that in Alberta for over a century now through the Métis Nation of Alberta, and they continue to do that through implementing the Otipemisiwak Métis government. So now they're in the process of transitioning and setting up those district councils in all the 22 districts, setting up their judiciary branch, setting up their ombudsman, and all of the different pieces that we've always wanted within our government, but, have had challenges because it didn't quite fit into corporate bylaws under the Societies Act. The time is now. We are implementing Métis self-government in real time through that Otipemisiwak Métis government constitution and through ensuring the passage of Bill C-53. And it's a really exciting time for the Métis Nation because we're getting closer and closer to that vision that Riel has always had and our people have always had of knowing that no one can take care of our people better than ourselves, and that we can govern ourselves, and that we don't need anyone's permission to do that. All we need is a government on the other side of the table respecting the true history of Canada and finally dealing with us on a nation-to-nation, government-to-government basis.
And that's an excellent place to conclude. We've been speaking with Métis lawyer Jason Madden, who clearly has a great passion for Métis self-government aspirations, as well as tremendous legal knowledge and historical understanding. It's been an enlightening conversation. Thank you, Jason.
Thank you.